Good morning, everybody. My name's Tony Fogarassy, aka Tony Smith. Thanks for the introduction, Kirby. Thank you to the chiefs, matriarchs, and guests who are here today to participate in this, what I think is very much a groundbreaking session on Mining 101. Also joining me today is Victor MItander. As you heard, Victor is from Yukon Territory, from the Selkirk First Nation specifically. And he and I work on various files involving Indigenous peoples in terms of exploration and mining in the Cordillera, which is generally the western mountains of North America and British Columbia and the Yukon principally. In terms of the session that Victor and I have crafted, we've put together a PowerPoint presentation, which will go up on the screen here, of course. You've got the first slide. We do have hard copy versions of the presentation in the back. Now, I don't know how many were printed, but if you don't have one, it's not the end of the world. I know Adrian and the Skeena Wild staff will be circulating all kinds of documentation, including our PowerPoint for those that don't have a hard copy. You'll get it in digital form. In addition, Victor and I have assembled approximately about 10 pieces of supplementary information, which is not designed for you to read page by page. You'll receive that as well in due course, but I will refer to a couple of documents in that supplementary information which will assist you as chiefs, as technicians, as citizens of the Greater Gitxsan Nation to consider and make decisions on exploration and mining projects. Next slide, please.
Sorry about that.
Thank you, Adrian. The outline of our session this morning is displayed up here, and as Kirby mentioned, the title is Implementing the UN Declaration into Mineral Exploration and Mining, and the word implementing or implementation is a pretty big word these days when it comes to the UN Declaration on the Rights of Indigenous Peoples. Victor and I had spent many, many hours crafting this presentation until, well, about 2 weeks ago, a decision came from the BC Supreme Court called the Gitxaala decision, which I'm sure many of you are familiar with. We will touch on that decision as it weaves in and out of our presentation. It has thrown some of our key points, or put some of our key points to the side, because we do want to spend a little bit of time on that decision to bring you up to speed. Just listening to the introductions this morning and the emphasis on exploration, the emphasis on the lack of consultation, the lack of notice, etc. This is what Gitxaala speaks to. And I'm hoping that Victor and I will be able to impart some specific information and knowledge on you. And it's wonderful you're all here to learn. My experience throughout the province is what you're doing is very groundbreaking. There are very few nations that take the time to sit down and to go through a session just like this on a particular topic, in this case exploration and mining. We're at the front end of a very important time in human history. And I know that sounds a bit over the top, but we've got something called the energy transition. And the energy transition means we're migrating from fossil fuels to renewable power over the next years, decades, and beyond. And to do that, to renewable power, to make the transition to reduce hydrocarbon dependency, we need, when I say we, society generally, globally, all 8 billion people on planet Earth require minerals. And where are those minerals going to come from? They're going to come from your backyards at the end of the day. And when I say that collectively in terms of Indigenous peoples in British Columbia and across Canada and around the world. As you may appreciate, the world has about 8 billion people, 400 million identify themselves as Indigenous. So approximately 5% fall into the category of being, quote, Indigenous peoples. And this is a number from the United Nations in terms of their statistics. But going forward, 50% or more of the minerals that will be required for the energy transition will come from Indigenous lands. So there's going to be a significant amount of pressure on certain First Nations who have an endowment that the Creator has provided them in terms of mineral resources, and they're going to have to make very important decisions going forward. And what you're doing today is the first, it's very much I don't want to call it a baby step, but it's a very critical, important step to get out of the gate, to listen to people like myself and to Tierra Neighbor, and you listen to Judy and others and Tara. Information is what it's all about, and we're hoping to download as much as we can over the next 2 days, and myself over the next hour with Victor. So quickly, in terms of our session, I was going to introduce Victor and myself a little more in detail, but we can leave that till later. We've already provided a bit of an introduction. What I'm going to talk about, and I'm going to get into, is provide the framework of exploration and mining from a legal perspective here in British Columbia. And that means dealing with topics of what we call Crown Law, United Nations Declaration, and what we call international law. And finally, to make some comments with respect to where the law is likely headed. We're also going to speak a little more in detail about the mining life cycle through the United Nations Declaration. Now, tomorrow, Judy will provide some real nuts and bolts perspectives in terms of the Mineral Tenure Act, the Mines Act, the Health, Safety and Reclamation Code for Mines in British Columbia, and so on. We'll touch on a lot of what Judy will touch on, but we'll touch on it from an Indigenous peoples UN Declaration perspective. And time permitting, of course, questions and answers. Kirby, of course, says it. I'll say it. If you've got questions while I'm talking, please interrupt, please ask. I know we're all too polite to do that. But I'm here for the next 2 days, and if you've got questions that you'd like to ask over the lunch hour, during breaks, or afterwards, please do approach me. Next slide, please. So getting into some of the basics, the high level of where mining law has come from, if you will. And as we're all aware, it all started with the papal bulls, so-called, so laws that came out of the Vatican back in the 15th century. So the doctrine of discovery and terra nullius, we've all been exposed to those doctrines, of course, through the processes with the Vatican. But it was really those doctrines which backstopped, of course, like colonial settlement of North America. In 1846, there was something called the Oregon Treaty, which resulted in creating the boundaries that we see now. So 1846 is a really important year in terms of Indigenous law as between back then Britain and the United States. Now, when it comes to exploration and mining, 1851 in Haida Gwaii is where the first prospectors discovered gold. So that is a point in time where gold entered the lexicon of Indigenous peoples in a fairly significant way from a colonial standpoint. Part of the reason for the interest in gold back in the 1850s was that the value of gold was viewed as being more than the fur trade at the time. And over a period of years, about 15 years, that turned out to be the case, where the value of mining gold and the profits to be extracted from gold were, I'd say, an order of magnitude more than the fur trade. So you had this decline in the fur trade, and you had this massive increase in gold staking, gold exploration through the 1850s. Because of the value of gold, in 1857, the British government, the British Crown, declared that it owned all the gold underneath your feet. And I'm sure your ancestors had no idea this was happening. 1858, with that proclamation, was the gold rush in the Fraser River. That was also the time when there was the Fraser River War with the Nikaman Nation. lots of fairly sad events occurring at that time in terms of Indigenous communities being overrun with prospectors. In 1871, British Columbia joined Canada under a very specific set of terms, which are called the Terms of Union. 1876 is the Indian Act. Then in 1938, there were two orders in council passed. One in 1938, pardon me, called BC OIC 1036, and another one in 1930 called PCO, which is Privy Council Order, that's the federal government. And there was another that was passed in 1961 by the BC government, and this set out the establishment of reserves, actually creating the reserves, and the history of reserve making, particularly in British Columbia, as I think we're all aware, is very complicated. In part to build the railway across Canada and the so-called railway belt and the ownership of federal lands in British Columbia after 1871 created a lot of legal issues as between the federal and provincial crowns. But it's these two this PCO order and the OIC, so-called 1036, it is these orders that set the groundwork for the governance of minerals on reserve. Now you heard Tierra earlier speak about the geological potential of the Gitxsan territory, generally using a provincial database called MinFile. What also exists beyond MinFile are reports of the federal government who about 30 to 40 years ago examined every single reserve in British Columbia for its mineral potential. And in terms of information that your management office would have at your fingertips in terms of on-reserve mineral potential, it would be well worth getting a hold of that specific information. And I'm happy to assist you with that, but it's something that could supplement all the provincial information. Well, the federal government, surprise, surprise, for 9124 lands for reserves, also has its own set of geological information. You know, what's the mineral potential of reserves? Some reserves will have no potential, some reserves of course will be populated and there'll be nobody having interest, but we found in British Columbia, Victor and I, through our travels, there are a number of reserves which, ironically, are right beside mine sites that have been producing metals for 10 or 20 years, but the reserve itself has not been touched. And that, by some nations, and I'm not saying for Gitxsan, but certainly some nations view that as a potential asset to monetize going forward. Next slide, please. So in terms of provincial crown law, and I make reference to Kirby's point that, gee, the Gitxsan should be making its own law and its own policies. I'll try to bring up a little bit of that later on because a number of nations have done this, and I think there's a lot of learnings that you can have from some of the nations in the interior and certainly up in the north. Created, I think, fairly elaborate policies as well as laws, which you might learn from. So in British Columbia, we have two primary statutes that regulate exploration and mining. One is called the Mineral Tenure Act, and the other is called the Mines Act. The Mineral Tenure Act, and tenure means title, it means rights to the minerals. That statute has that one purpose. It sets out the process to how somebody can stake your land, develop a prospect, take it to a mine, etc. So it provides the process to get the rights to do that. That act, that piece of legislation, is the subject of the Gitxsan litigation, which I'll get to in a little while here. The Mines Act is the operational end of the exploration and mining continuum. It really does regulate everything from soup to nuts in terms of what can be done on a mining claim or a mining lease, or a placer claim or a placer lease. And those nuts and bolts, as I mentioned, Judy tomorrow will get into in more detail. Within the Mines Act, there is a code. It is a regulation, it has the force of law, It's known as the Health, Safety, and Reclamation Code for Mines in British Columbia. It sounds like a mouthful. It sounds like something that, you know, your eyes are going to glaze over and roll to the back of your head. Who's going to read that document? Because it's probably about 300 pages long. But it is a very important document from a UN Declaration Indigenous Rights perspective, because like the Mineral Tenure Act and like the Mines Act, it needs to be rewritten to reflect progressive 21st century principles when it comes to Indigenous rights and title. So those are the two pieces of legislation on the ground that geologists and everybody around geologists, geophysicists, engineers, and the like would be familiar with. The third bullet here, of course, is the Declaration on the Rights of Indigenous Peoples Act, and this is the provincial legislation that came out in November of 2019. This legislation was subject to the Gitsala decision from a couple of weeks ago, and I'll touch on that as we get into the presentation. Now, other pieces of legislation, other statutes, regulations include, as I'm sure you're familiar with, many of you are, is the Environmental Assessment Act, which was repealed and replaced. It was completely rewritten in 2019 to provide a little more space for Indigenous peoples to be involved in the provincial environmental assessment process. It didn't meet the test of the UN Declaration for true consent. It's a small step in that direction. It is in the context of all the other Crown legislation we've got, is still considered to be a very progressive piece of legislation. There is complementary federal legislation under the Impact Assessment Act, which may or may not come into play depending on the impacts the project might have on federal authorities. Other statutes to be aware of course, the Environmental Management Act and the Mineral Tax Act, and various other statutes. I put the Mineral Tax Act in here, but what you've mentioned this morning in terms of logging, for example, where logging has occurred for 50 years and essentially haven't seen a nickel from it. And now what's going to happen with mining? If you make the decision in terms of your houses as the people to allow mining to come into your territory over the next number of years and decades, how are you going to benefit from it? And I'm sure there are hard lessons that were learned from the forestry sector. Now the challenge will be for you to get the skill sets and the knowledge and to get the right advisors, because there's a lot of not so right advisors out there, to allow yourselves to be positioned to get the best deal possible going forward. And look, I'm not here to be an advocate for industry, but there might be a situation where a house or a watershed group, they decide, you know what, we can build a mine ourselves, and maybe we can benefit much more directly from an activity such as that. Now these are, in these first 4 bullet points, statutes that I've referenced. The 5th bullet point is what we call judge-made law, and judge-made law is just that. It's the various court decisions that we're all familiar with, and as a lawyer, I'm quite honored to be in the land of Delgamuukw in terms of, yes, way at the back. The question that was posed was the application of trespass laws vis-a-vis Gitxsan and the provincial crown, and why there essentially isn't the recognition from a crown perspective of trespass as the Gitxsan view trespass. And the simple answer is this: there are trespass laws that are similar to a crown law, that are similar to Gitxsan law, but exploration, mining are viewed as a greater purpose in terms of the land. And as a result, provincial trespass laws are subservient. In effect, they don't apply. And so the same logic is used for Gitxsan. I can't speak to obviously specific to Gitxsan trespass laws, but the principle is the same. If you're going to go into somebody else's territory, you've got to have their permission. It's the same thing in Crown law, but the way Crown law is written, in terms of the Mineral Tenure Act and the Mines Act, the Mineral Tenure Act specifically for access, is that even though there are laws of trespass, those laws effectively are not applicable. This slide is titled the United Nations Declaration on the Rights of Indigenous Peoples, also known as UNDRIP. Many of us try to call it the UN Declaration, which I expect you probably do as well. UNDRIP is not the best acronym. I made reference to the Gitsala decision from the BC Supreme Court from 2 weeks ago. And that was a decision which had two significant findings. And one was on the duty of consultation with respect to mineral claim staking, and the other was on the applicability of the UN Declaration into British Columbia law. Gitsala scored a win on the consultation end, and I'll get into the details of that shortly. But in terms of the UN Declaration law being welcomed into British Columbia and acting in a manner I think that we all expect it to work in, especially from mining, from a free, prior, and informed consent perspective, the court shut that door with a bit of a toehold where First Nations down the road can revisit this particular topic. And when I put in the first bullet point, the sub-bullet point, I say binding or not, we know now from the BC Supreme Court that the provincial legislation, which has brought in the UN Declaration, for the most part does not apply for the purposes of the Mineral Tenure Act. You know, 2 weeks ago, the Gitsala decision came out, and Adrian and I spoke about, well, what's it going to say? What might it say? And we said, well, we don't really know until it comes out. And it came out. And so it's thrown the presentation by Victor and myself into a bit of reshuffling of the slides in the slide deck. So Gitsala is this. Approximately 2 years ago, the Gitsala First Nation, Kitkatla, located about 70-80 clicks south of Prince Rupert by floatplane or by boat, they started what we call a petition, a legal action in court. And what that means is a court case where you only have to file documents. It's not a court case where you bring in witnesses who testify and get cross-examined and so on and so forth. So you have Gitsala coming forward and filing a whole bunch of documents saying there are mineral claims on our traditional territories, on our ancestral lands that were registered, that's the official word, or staked, that they were staked and registered without us being notified, without us being consulted, and certainly without our consent. And so we are now challenging those mineral claims that have been staked because the Mineral Tenure Act is unconstitutional. The Mineral Tenure Act does not require consultation before a claim is staked. And the Gitsala argued to court and argued successfully that consultation must occur before a claim is staked. So that's the big finding for Gitsala. It's very much a watershed decision. It's exceptionally important because it's almost at the beginning of the exploration process. Now we all know, and we've heard here this morning, you have people wandering around in your territory. They might not have staked a claim, but they're certainly walking around, moving around in ATVs, what have you. So they're already accessing your lands without staking a claim. But generally speaking, when you stake a claim now, the Gitsala court, the decision there, it's a one-person court, in this case a judge from the Supreme Court of BC, said that the Mineral Tenure Act to stake claims accompany a free miner, as they're known, because only free miners who hold a certificate from the government can stake claims. They must now have fulfilled, or with the Crown, have fulfilled the duty of consultation and where necessary accommodation. So language I suspect many of you are very familiar with in terms of Section 35 rights. So what the Gitsala decision said is that if somebody's going to come into your territory and stake a claim, the duty of consultation has to be discharged. And as we know, it's not officially done by the proponent, it's officially done by the Crown through one of their agents. And in British Columbia, as we all know, there are thousands of mineral claims. There is no consultation process in place. So what the court said is, well, it would be a burden on industry, it would be a burden on everybody to have consultation in effect immediately for any new claims going forward, and we're going to grant, this is the court saying, we're going to grant an 18-month grace period. So over the next 18 months, you will definitely receive overtures from Victoria and Energy Mines and Low Carbon Innovation in terms of designing a consultation process for the staking of mineral claims. A hugely important decision when it comes to where does the duty of consultation, where do Section 35 rights fold into the exploration process? And look, you can't build a mine without the mineral title, without the mineral claim. The claims get converted to leases and into mines and so on. But if you don't have that initial, and it's very much a proprietary document that you have virtually in your hands, it's all done online, which is another very significant part of the decision, because when you stake something online, of course, it's done instantaneously, it's done without notice, and at the end of the day, the court viewed that in a very negative light. So when you go home tonight and you say, gee, what did Tony say about Gitsala on staking? There is a duty to consult, but it's not going to happen for 18 months. The government's going to set up a process. Gitsala must be in the middle of it. And it must be in the middle of it because of what Tara mentioned in her assessment report. There's geological potential. It might take 1, 2, 5, 10, 20 years before some of that potential might be a mine or potentially a mine. But you're starting early. You're starting at the right time to get involved. And the Gitsala decision allows you to get in front of the proponents, those who are on your territory who are looking to stake claims, because they need to consult through the Crown officially. Proponents need to interact with you to get your, not to get your permission. The law hasn't gone to the point of consent. It's gone to the point of consultation. So something to bear in mind there. In terms of the 18-month period, let me just make this general comment. There is some speculation that there could be a bit of a staking rush in many traditional territories around the province that have prospectivity from an exploration and mining standpoint. I think what will happen is you will see a lot of activity next summer in terms of exploration, and then next fall, before the 18-month period is up and a consultation system has to be in place, next fall I suspect you'll see a flurry of staking activity. Now, whether there'll be a lot in Gitsan territories, I don't know, but looking at a little bit of what Tierra's got there, look, I'm a geologist as well as a lawyer. Yeah, there's some interesting areas in Gitsan territory that, yeah, maybe I'd have a look at. And so if you've got somebody who's already in there, maybe they'll stake more lands. And they're able to do it without, quote, consulting. Now, there are progressive companies out there who will take the time to sit down and speak with the houses and with the leaders and the decision makers in your communities and request consent, say, can we stake? Those companies are relatively rare, but they do exist, and I'd say there's probably about a half a dozen that I know of in my travels that do exactly that, where they'll step into a band office, they'll step into an office and say, hey, look, we're thinking of staking a claim. Are you okay with that? Some companies take it to the point where they say, before they set foot on the land, they'll say, we're thinking of setting foot on your land. Are you okay with that? And we might come back to you to talk about staking some claims. So there are some good case histories. There are some examples out there that I suspect Gitsam would be well advised to learn about and to get more sort of in the loop as to, you know, what might make the most sense for you as a nation going forward. So the Gitsama case, even though it started 2 years ago and it was released, the decision, the judgment was released about 2 weeks ago, it is essentially a mirror case of a Casca decision called from the Ross River Dena Council, one of the Casca communities up in the Faro area of Yukon. And in 2012, so 11 years ago, they had a very similar case with a somewhat similar outcome where in the Yukon they found that before you can stake claims on Casca territory in the Yukon, because Casca territory extends, of course, into British Columbia and into NWT, that consultation had to occur before the staking of claims. The BC government, every time myself and others would go to Victoria to say consultations required before claims are staked, the government would say no, the Chief Gold Commissioner would say no. So for Gitsala to come forward, as they did, to really be the community to spearhead getting consultation into the claim staking process is absolutely huge. Of course, we all here wanted to get it to the next level. I can't provide an answer on that. I'm getting it to the level of consent, especially consent viewed through the United Nations Declaration lens of free, prior, and informed consent. Consent, Kirby, I'm going to run out of time here as we go on, but that's okay. Right. But there's a lot written about consent. There's consent and there's consent. So I'm going to give you a bit of law here in terms of consent. There is what I call the UN Declaration form of consent and free, prior, and informed consent. And I was talking with Judy this morning. Judy's got a long history in coal exploration and mining. There's a First Nation within the Ktunaxa Nation called the Tobacco Plains Nation, and they've got a coal project on their territory with a couple of companies from New Zealand and Australia. Well-capitalized companies, but companies who at the end of the day said, we are going to agree to free, prior, and informed consent on everything that we do with our coal project. So they have, in terms of their dealings, the proponents from Australia and New Zealand have reflected in their dealings with the Tobacco Plains First Nation the whole notion of free, prior, and informed consent. And this is something that occurred about 6 months ago. Now remember, I told you, it's great. You're at the beginning of a lot of really good stuff happening and positioning yourselves as to where the law might go and to help you make decision-making going forward. Now, the other form of consent, which you may have heard of, is consent with respect to Aboriginal rights and title. And that involves the court case with the Silco team in 2014, so 2014. And that was a case which dealt with Aboriginal title. Look, I know I'm speaking to Delgamuukw here, so bear with me. That spoke to Aboriginal title in terms of Aboriginal title being found to certain lands that the Silco team owned. The notion of consent is woven into Aboriginal title, as we know through Delgamuukw and other cases. But it's a slightly different form of consent because that consent can be justifiably, at the end of the day, that right that constitutional right can be justifiably infringed by the Crown. So it's not quite absolute control over your territory from a consent standpoint. So this is why lots of nations and legal thinkers are excited about the UN Declaration, because it takes it up a notch. Because when we're talking about free, prior, and informed consent under the UN Declaration, we're talking about inherent rights and title. So when you hear about Aboriginal rights, that stems from the so-called empty box of Section 35, of which started back in the day with the Sparrow decision, fishing, obviously with Delgamuukw, Haida, and a whole bunch of other really good decisions. But those decisions dealt with Aboriginal title, a Crown construct, a colonial construct, versus everything that you have had and still have as a nation up to, remember I mentioned 1846, sort of the date of first contact, as determined by the Supreme Court of Canada in one of its decisions in terms of Indigenous peoples in the British Columbia area. That differentiation is important to note because you're going to hear a lot of legal speak of talking about constitutional rights, so that's Aboriginal title and treaty rights, which are protected by the Constitution Act of 1982 of Canada. But also now with the emergence of inherent rights, so rights that and title that you as a nation had before 46, and continue to have to this present day. And it speaks to the question that we had earlier on regarding trespass and Gitsan laws and how does that feed into it. So you're going to hear a lot of discussion of how Crown law views this emergence of inherent rights and title. Whether or not exploration and mining will catalyze a lot of that discussion remains to be seen, but from a Gitsala litigation perspective, it helps set the table. It allows all of you to engage in that conversation going forward, is how do you elevate, it sounds like a pejorative, I get it, but how do you bring the Crown down and you truly have jurisdiction and authority on your traditional territories, on your ancestral lands, right? That ultimately I think is the ultimate objective, and have that recognized by the Crown. And so what the Gitsala decision has provided, that first small step, it's a constitutionally related step in the sense that you need the duty of consultation and where necessary accommodation to be satisfied by the Crown. Okay, well, question, yes? The question was, in terms of a consultation process that will be crafted going forward over the next number of months, who's going to do that? What's the process? How's it going to work? Because the experience from the forestry sector, there was a similar initiative which really fell flat on its face and was not acceptable. I can't speak to that because I don't have any specific information. What we've heard is the government is burning the midnight oil, trying to figure out the Gitsala decision and try to do things that make sense, obviously for not only Gitsala, but for all Indigenous peoples in the province. But there's a bit of a fly in the ointment here. Unfortunately, what's going to happen next year? There's going to be an election in British Columbia. So Premier Eby is going to call an election, and we all know what that does, right? It grinds the wheels to a halt. So the question is very appropriate. In terms of First Nations leaders and technicians that interact with energy mines and low carbon innovation in Victoria on a regular basis, that's a question that should be asked at every opportunity. And not well, what's going to happen? It has to be, we want to be at the table and involved in designing that process. Don't let, because you'll be down that forestry path, I suspect, again, right? They're just going to present it to you as signed, sealed, and delivered, and away they go. We've all learned from our mistakes, frankly, over the last generation or so, with Aboriginal rights and inherent rights really coming into their own and being recognized. So the government knows it's in the limelight in a way. The spotlight's on it right now in terms of what it's going to do with this process, in terms of developing a consultation procedure, if you will, for the staking of claims. Now, to complicate things, I mentioned the election next year, and this 18-month period where, this is Tony's prediction, you're going to just see more staking after next summer before this 18-month deadline hits. The reason TIER's report is really useful to you is because there is an enormous initiative underway to assess critical mineral potential in British Columbia and across Canada, and indeed in many countries around the world. Remember, at the beginning I talked about the net zero, the transition from hydrocarbons to renewable power, etc. Well, the minerals that are required there are what we call critical minerals. The irony is, just about every mineral, every metal on the periodic table is now critical. There's more than 60 of them. Some of them do exist, obviously, in your traditional lands. And the government, as we speak, as Adrian kindly pointed it out to me, that, last Friday, the BC government launched an engagement initiative with the public and with Indigenous peoples on developing a critical minerals strategy. So again, this is something that Gitsan absolutely needs to be in the room on. The government says, well, we'll conduct bilateral meetings with governments G to G. We'll go through all of that. I don't know if they will or not. But be alert, be proactive, and say, hey, we want to be at the table for this. And not at the table as an observer. We all know the difficulties in funding, because you're going to need the right advisors at your elbows to make sure you get the right messaging out, etc. So that's got to be part of the equation going forward. I don't know how the government's going to deal with that, but that's a really important piece. But this critical minerals piece, I can't underestimate the train coming down the tracks. There is going to be a huge demand for a whole host of minerals and metals over the next generation. And again, for the third time, it's great that Gitsan, we're having the Mining 101 workshop today to sort of start thinking, okay, what does this all mean? We've got the critical minerals process that Tony's just talked about. He's got the Gitsala decision on claim staking. That's really positive from a consultation standpoint, not consent, but still positive. There's another thing that you should be aware of, and again, you probably want to be in the room on, is that the Mineral Tenure Act, the very first piece of legislation I mentioned, subject to the Gitsala litigation, is going to be modernized. Now, the government announced a number of months ago through the action plan supporting the BC Declaration Act that it is going to modernize the Mineral Tenure Act. So again, something for leadership and technicians to be on top of, and not to receive information. My view is, you have to be the bull in the china shop. You've got to get in and say, hey, look, we know you're doing this. Invite us into the conversations, please. We want to know what's going on, and we want to be able to represent our people as faithfully and as fully as possible. Okay, long-winded answer. I'm a lawyer. You got to put up with it. All right, so look, I've touched on a couple of these points on this slide. Don't go yet, just wait. At the very last point, critical minerals. I call it First Nations Critical Minerals Strategy under development. There is a sectoral council called the First Nations Energy and Mining Council that conveniently Victor and I consult to, and I'm their lawyer. They are carrying out a series of 4 workshops in October, November, and January. Later this October 20th, November 22nd, and January the 9th. And they are looking for feedback on creating now this is a British Columbia-wide policy, so it's not geared specifically for Gitsan, obviously, but they are seeking to create a First Nations critical minerals strategy. Not a BC government strategy, which is underway right now for engagement. The federal government already has a critical minerals strategy. The US government, the Japanese government, the German government, every government on the planet that needs minerals and metals have now developed critical minerals strategies. So coincidentally, just BC and First Nations through the First Nations Energy and Mining Council, which is a sectoral council of the First Nations Leadership Council, just happened to be doing this at the same time, literally at the same time. But the government has already indicated to the First Nations Energy and Mining Council that it would like to align strategies of the BC Crown with whatever might be proposed for a First Nations critical minerals strategy. I know for a fact that you will, well, for those who are on the right list, because there's always issues with distribution lists, you will have received notices from the First Nations Energy and Mining Council for these webinars and to request that you register for them if you're interested. So I would certainly advise that you do so, in part because I think they've slotted Kirby and myself to give a talk, so it's definitely worth attending, right? But in terms of First Nations positioning themselves, the FNEMC, First Nations Energy and Mining Council, aren't rights and title holders. They need nations, the rights and title holders, to come forward and say, this is what we need, this is what we need. We don't want this, and we don't want that. And to get that into a province-wide policy. And it's a very elaborate process. There's no shortcuts to this. And you're saying, Tony, but if it's just a policy, if it's just a strategy, who cares? It's not law, it's not the force of law. Yeah, but it starts to set the tone and it sets expectations. And the critical minerals sector is a sector that, when I spoke about gold being an order of magnitude more valuable than the fur trade back in the mid-1850s, and that's why the gold economy took over in British Columbia, well, the critical minerals economy is going to take over almost every sector on the planet. And we've all heard about electric vehicles, for example. Electric vehicles, particularly because they have batteries, require a whole host of critical metals. Your phones, your devices, your computers, everything else. There is such a demand for critical minerals that even the most pessimistic of folks out there are saying, yeah, it's going to happen. There's just going to be this tremendous pressure on the land base. So land use planning, there are some initiatives that are happening provincially from a land use planning perspective that look through a geological exploration lens. I don't know if you're in touch with any of that. I've seen little bits and pieces of it, but the government has kept it under wraps, generally speaking. Maybe Adrian and I can have a discussion later on, and we can put our heads together as to what the government has got online on that and what they're publicly circulating from a land use exploration perspective. Next slide, please. The question from Robert was, in terms of critical minerals and the uptick in activity, a significant uptick in activity, what has been done from a study perspective on impacts and so on? And right now, not a lot. And you've hit a bit of a touchstone with respect to a First Nations critical mineral strategy, where it would very likely focus on exactly the matter that you've raised, that things have to be done right and done to these specific standards or expectations. And when I say standards, again, standards aren't law, unless they're expressly incorporated by reference, as lawyers like to say, into a statute. But there are mining standards which involve environmental assessment, involve reclamation, etc., from stem to stern. These are voluntary mining standards. And there's probably 24 of these standards that exist around the world. And again, they're voluntary. And they're created by industry in some cases. They're created by sector-specific portions of industry. Like the copper industry has its own mining standard. The Mining Association of Canada has its own mining standard. In terms of a mining standard, which could feed into a strategy for First Nations, would be one that's developed by an NGO called the Initiative for Responsible Mining Assurance, IRMA. It is in my slide presentation, so if you've got a hard copy of it or look at the digital, you'll see IRMA referenced in there. IRMA is the only standard on mining globally, and this is mining now, right? It's not exploration, it's not processing, smelting, if you will, refining of ore, it's on the mining of ore. It is the only one to expressly reference and adopt free, prior, and informed consent in the UN Declaration. It's a very comprehensive mining standard. It runs in the hundreds of pages, and with policy and procedure manuals behind it into the thousands of pages. It is voluntary, right? So it's not a law, but it is definitely the high bar in mining practices on planet Earth right now, today. And you'll see a graphic in my presentation where it shows where IRMA is displayed on a graph with respect to the quality and the comprehensiveness of mining standards with about 15 other standards. IRMA is head and shoulders independently rated as the best mining standard in the world. Now you're going to say, well, okay, so what? So what's the big deal about having a mining standard? How's that going to affect British Columbia? How's that going to affect Ontario? How's it going to affect Gitsen? It is in this manner. Members of the IRMA organization include, right, so these are pretty significant players. They include Microsoft, Tesla, Ford, BMW, Corning, all massive companies who want to source every atom of mineral or metal sustainably and responsibly. And their view of sustainable and responsible mining is when it's done in conformance with the UN Declaration on the Rights of Indigenous Peoples and free, prior, and informed consent. So this IRMA mining standard is reaching critical mass. It's having more and more companies sign on. There are mining companies that have signed on to this standard. There are mining companies now that are being audited by third-party independent auditors in terms of their mining operation, because they know they need the IRMA seal of approval on their mine to sell their metals to Tesla. That's what it comes down to. And for Tesla, yeah, you could get his nickel from Indonesia, but Indonesia is one of the dirtiest mining countries on the planet, bar none. They'd much rather get nickel with free prior and informed consent from a nation, British Columbia. Thank you very much. It's just logical. And it's not coming from the corporate head offices of a Tesla or a Ford or a Microsoft who buy hundreds of millions, billions of dollars of metal each year. It's coming from the shareholders, because shareholders now are litigating some of these major companies by saying, you know what, all the cobalt that you have in your batteries in your electric vehicle comes from the Democratic Republic of Congo, and the Democratic Republic of Congo uses forced labor, uses child labor. And so shareholders are saying, not anymore, you're going to get your cobalt from Canada or Australia, which is a major source of cobalt. Now there's some interesting issues that one could argue, well, is that good for the economy of Democratic Republic of Congo, etc. But major companies have made this decision in the last few years. You're seeing the pendulum swing to sourcing minerals that are responsibly and sustainably mined. It's a bit of an oxymoron to say those words all in one sentence, sustainable and responsibly mined, because there's always impacts from mining, as we know. But the IRMA standard, I always encourage nations to reach out to IRMA, at least get a presentation from IRMA on Zoom, and they can run you through their standard and to tell you why their mining standard is one that you should advocate for when the British Columbia government is looking to retool the Mineral Tenure Act or the Mines Act or anything else related to mining. Now the exciting part for IRMA, hearing all the exploration discussion in the room, because we know most of the impact on the land generally is from exploration. Yeah, you get a mine popping up here or there every 10 or 20 years. There just tends to be a lot of exploration activity. The IRMA mining standard will be extended to exploration and to mineral and metal processing or refining, and that will occur next year sometime. So it'll be a very comprehensive standard that runs from, literally from staking claims, accessing your territory, through to reclamation. ESG is more of a financial corporate governance tool and tends to be a bit vague in terms of what it really means. It's very much in a state of flux. It's only come into its own a couple of years ago, as we know. IRMA, it's there in black and white. It's pretty specific as to what you have to meet to get the, what we call the IRMA, what IRMA calls the IRMA certification in terms of a mine. You might ask the question, well, does IRMA, have they certified any mines in Canada? No, not yet. They've certified mines in Africa and South America and Central America and so on. But there really hasn't been any uptake by Canadian mines to be audited, right? This is an independent auditor coming in and looking at your mine operations. Maybe at some point in time they will. I suspect that will be the case. But again, I'd recommend to the chiefs and technicians, do reach out to IRMA. I can supply you with the email and contact information of the staff there. One of whom is in Vancouver and another one is in Seattle. They're a global organization with representatives around the world. And if anything, you'll learn a lot about the mining sector because they'll bring a global perspective to it. They're certainly following what we're doing in British Columbia from a legislation. In fact, in the Gitsala case, IRMA kindly put in an affidavit to explain what it was all about and why the court should consider standards like IRMA specifically and when it makes decisions in terms of mining disputes. Well, the process is you go onto a computer and you outline an area on the map, you click on it, you pay so many dollars for each hectare of land that you claim, And once the payment has been processed with your credit card, you are then the mineral title holder to those claims. You need to be what we call a free miner. You pay $25 as an individual to be a free miner, so it's next to nothing. Companies have to pay $500, but that's just the cost of doing business. But there's no bars to entry. Once you've got a free miner certificate, you're off to the races and you can stake online. No, you can, they can claim, yes, absolutely. Right now, the current system, it's called Mineral Titles Online, or MTO. You're allowed to stake anywhere in the province except for, of course, parks and protected areas, reserves, Indian reserves, and various federal government lands which are off limits to provincial legislation, so military installations and the like. So barring that, and you can't stake under somebody's house, so that we know, but you can stake within 75 meters. You can actually mine quite close to a dwelling. So that means, in my mind, I think of at least 70% of the province is open for staking. So if somebody had enough money, right, they could actually stake the entire province. There's nothing stopping a company from doing that. It's just that when it comes time to renew the mineral title in a year's time, and you have to renew it each year, then the fee does go up significantly. Yes. Yeah. There are some jurisdictions, even though we haven't had Victor involved in the conversation, he'll tell you in the Yukon, $100 will get you a mineral claim for life. So every jurisdiction is a little bit different. Oh, in terms of claims in British Columbia? If you keep renewing them, they're forever, absolutely. Yeah, there are claims that companies have had on their books for decades, absolutely for decades, but they've got the treasury to pay the added fees. There's an added fee per hectare that you can keep for these mineral claims. Kirby, if we can go to slide 16, please. Yeah. So consent. I mentioned earlier on the work of the First Nations Energy and Mining Council, done through resolution by the Chiefs in Assembly and through the various organizations that make up the Leadership Council, but the rights and title holders pointed to FNEMC and said, we need something on mining and consent that we can circulate to all the nations in the province. What you see here is a document called Indigenous Sovereignty, Consent for Mining on Indigenous Lands. This is a report that was supported by the BC Law Foundation. So my legal fees as a practitioner, to be a barrister and a solicitor, etc., a portion of my fees went to paying, I'm proudly to say, for this report. This is a must-read, again, for leaders and technicians who have not seen this document. It's quite comprehensive, but it's high level enough where you don't have to worry about, well, the details of how many dollars per hectare, etc., that we're discussing a little bit here. It brings it up above that level, but it goes through where consent needs to be infused into the exploration and mining process. A document that's available online at the FNEMC website, which is simply FNEMC, First Nations Energy Mining.ca. The report was released about a year and a half ago. It was released, of course, to time for Roundup in Vancouver in 2022. I don't know when FNEMC plans to release in January this year, but I suspect it will release something, particularly when it gets out. So, by way of the information, and again, one of the takeaways I heard this morning from many of you was you're here to learn, to absorb, to listen. You will learn a significant amount about consent and mining when you have a look at this report. So I highly encourage you to have a look at it. For those that want to drill into the details, there's another version of the report which is about twice as long, which has all the detail and all the footnotes and everything you could ever want regarding this report. So there's a shorter 50-odd page report and a 90-page report and there's just a wealth of material that gets into Aboriginal rights, treaty rights, inherent rights, consent in the whole exploration and mining space. Absolutely a must read. In my view, maybe not so much a year and a half ago, but where we're at now with the Crown, the Gitsala decision, critical minerals, right, yada, 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 you've heard me on this 10 times already, but we're at this nexus in time, and who knows where things are going to go going forward, but there's just a lot on the go. 2 slides ahead, please. Not that one. That one, yes. Okay. So this is a slide which I should quickly say Judy will touch on many aspects of this slide tomorrow from a process procedural standpoint, not from a UN declaration standpoint. That's why I'm here, obviously. But it is in the the presentation, which I don't know if there are copies in the back, but you'll get digital copies. But it nicely sets out the 3 major phases of exploration and mining. There's exploration, obviously, there's the whole regulatory process of getting to the point where you can put mine into construction, and it deals with closure. This slide comes from the Energy and Mining Council report. So there's a lot of language, there's a lot of information behind each of this 1, 2, 3, 4, and 5, from registration to exploration and so on. But already, because of the Gitsala decision, we can wonderfully update this slide by saying, you know what, gee, consultation now, is required. 2 weeks ago, I would have said in BC, there's no consultation, notwithstanding everybody's concern here, the angst and the apprehension of people in your backyard. There's no Crown requirement for consultation. There is from a good neighbor standpoint for doing the right thing. There are some companies that will do so. But now that we've got the Gitsala decision, we know for the purposes of staking, for the registering of mineral claims online, that consultation has to occur. But if you look at the far left of the slide, the very first word on the top of the arrow is called prospecting, right? So that's where the prospector, he or she, comes out onto your traditional territories. But for you out being on the land, fishing, what have you, you don't know what they're up to, you don't know what they're doing. And so what we're trying to do now is get the advocacy going where prospectors should not even show up and go prospecting with a rock hammer to take one rock sample until they've come in to visit with you as chiefs or your representatives or technicians to get the consent of your nation to do so. All right, I'm surprised Kirby hasn't said, Tony, sit down, because now we're reaching the lunch hour. Am I right, Kirby? Right, we're breaking at 12:30? Yeah, okay. So, right, so what I'm hoping is Victor can come back after lunch to speak about some legislative initiatives in Victoria regarding the Code Review Committee under the Mines Act. I appreciate that's a mouthful. You probably don't know exactly what I'm talking about. But can you go to slide 23, please, Adrian? We have a slide up here regarding the UN Declaration Subcommittee, which is a committee under the Code Review Committee under the Mines Act of British Columbia. And Victor, who is online, will speak to this slide and this particular committee and what it's doing from a UN Declaration standpoint. Over to you, Victor. Hopefully you're plugged in here on Zoom.
Thank you very much for the opportunity to speak. I'd just like to acknowledge where I am in Vancouver, acknowledging the unsurrendered Squamish, Stolo, Tsleil-Waututh, and the Musqueam Nation, and in their traditional territory. So I will be speaking to you about the UNDRIP, the United Nations Declaration for the Rights of Indigenous People. It was passed by the United Nations, and Canada has also passed the law. It's not binding, of course, and BC is also one of the first provinces to pass the law. And again, they're bringing into consistency with the United Nations Declaration. There's a lot of work that has to be done. When you look at the mining laws, affecting Canada and particularly BC and Yukon. Yukon is probably one of the first places to have pretty strong mining laws governing placer mining and hard rock mining as well. And we're in Yukon, we're in the process of developing new legislation, and it's based on the spirit of when devolution happened, devolving the federal responsibilities over management of laws and the lands and management of it, that they have to consult and involve First Nation governments as the legislation evolves. And this has been a process that's been going on for the last year or so since the Ross River decision and the courts stating that they have to consult and accommodate the First Nation interests. So right now, just quickly on the Yukon process, we do have the First Nations. There are First Nations that don't have final agreements or self-government agreements, and those First Nations is White River and Ross River, Denny Council, and Liard First Nation. And so, but they are part of the process developing the legislation. And so in Yukon, we remain to see what evolves in making sure that they respect the spirit and intent of the umbrella final and the self-government agreements and the lands that are retained by First Nations. And in the Yukon agreements, they do have subsurface ownership. It was a policy that was changed. We were managed to change the federal government policy dealing with subsurface interests going forward. The United Nations Declaration is a very important component as we evolve mining in Canada and particularly in the world, North America, and we're seeing standards that need to change to meet the new modern era going forward, dealing with the rights and titles and interests that First Nations have, dealing with their lands and going forward and making sure that we have a government to government process as we develop the particular resources. Critical minerals is an important element going forward. We're moving. We have to do that because of what's happening in the world with the temperatures and the carbon release. So we need to move to greener pastures, making sure that we do develop everything that is sustainable. That has to be sustainable if we move forward. Now, one of the things that we need to look at, the United Nations Declaration, we have a process in place with BC dealing with health and safety and reclamation code for mines, and we have a committee, a code review committee that's in place, which follows through on the Mine Act, and they are in the process and continue to be in the process of evolving, reviewing the laws or the code and regulations that govern mine codes. And these codes have to be updated. And so the code review process provides their findings to the subcommittee, and the task group provides specific focus on particular areas. And so we expect to see legislative drafters providing certainty dealing with regulations so that these kind of things are brought into conformity to the United Nations Declaration. There is a lot of work that has to be done. And so we look at what I see happening as we move forward. We see the FPIC, the free, prior, informed consent, is a critical part of ensuring that we have our own input and consent on anything that happens on mining development. And this is something that's important. If we move forward, we need to get what do we what are we talking about when we talk about free and informed, prior informed consent? What are the steps that are necessary to have that put in place? Because as we know, agreements that are negotiated between the mining companies and the First Nations are kept confidential. And so we need to have some way of making sure that these kind of things, as it moves forward, that there are some guidelines or some basic principles that set the standards on how and what should be included in the FPIC process. And so it's something that needs to be focused on as we move forward. And I think it's a key area that needs to be fleshed out when we talk about the duty to consult and to accommodate and to make sure that we have to ensure that these interests are protected as we go forward. The United Nations Declaration talks about important interests dealing with First Nation interests. We need to make sure that First Nation governments are part of the process going forward, making sure that they have their traditional interests, their inherent right, the hereditary rights accommodated, so that as we know right now, there is big conflicts between the laws under the Indian Act and what we call hereditary inherent rights that we have that needs to be recognized and accommodated. We do have a Section 35 right that's in the Constitution, and the way I see it is that it is a box that recognizes the inherent right of self-government as part of that process going forward. And we need to flesh that out a little bit more, making sure that these high standards that we want to see happening across Canada is respected. And so where do we start? I think we need to look at the United Nations Declaration and making sure that we have the free, prior, informed consent on all aspects dealing with First Nation lands and traditional territories. And we need to make sure that happens. How we do that, we have to do this in a way that we stand together and to recognize these basic principles as we move this process ahead.
Thanks very much, Victor. With that concludes our presentation. We don't want to get too far behind with Judy coming up, but just to quickly note, the UN Declaration Subcommittee, which Victor co-chairs with the Chief Inspector of Mines, this subcommittee is populated by a majority of Indigenous members, naturally, since it's on the UN Declaration. But it sees all the activity that's involved with amending, revising the Health, Safety, and Reclamation Code, which is a regulation. So it's a point of intersection, a contact point for First Nations to be involved in the legislative process going forward. This came into being last year. I think it's been a success in large measure. And we're hoping to see a lot more of First Nations being actively involved in terms of amending, revising, repealing, and replacing legislation, particularly, obviously, with what we're here for today, exploration.